A very good afternoon, everyone. Atal Mishra this side from the Department of Law, Mewar University. We are about to discuss the another unit, which is Law of Sales of Good under the Sales of Goods Act 1930. So, starting with a brief introduction, Law of Sales of Act 1930 governs contract related to the goods, sales of goods in India. It is also the act which is enacted before the by the British Parliament, by the Britishers. It regulates the transfer of ownership of good, define rights and liabilities of the buyers and the sellers, and set out the remedy of the for the breach of contract. The act covers the sale, both sales and agreement to sales of good. It is not just limited to the sale, which is when it is being executed. Again, coming to the definition, as per the section 4, a contract of sale is a contract where the seller transfer or agree to transfer the ownership of goods to the buyer for a price. So basically here two parties are involved. One is the buyer, second one is the seller, and there is a mutual contractual relationship between them when there is a transfer of good in the exchange of a certain price. So key points here are the sale, transfer of ownership of good from the seller to the buyer for a price. Second one is agreement to sell, a promise to the transfer the ownership of good in the future, does not transfer the ownership immediately. So here we need to understand there might be the future consideration as well. It is not mandatory that the sale would be and would take transfer of ownership would take immediately. Okay, so coming further to the condition of for the validity of parties, there must be at least two parties, buyer and the seller. Subject matter, the subject matter of the sale must be tangible and movable item, and price, there must be an agreed price of the good. Again, these are the three prominent conditions to substantiate the Sales of Goods Act. The first, the parties, most important, we have already discussed. The subject matter is really important. The emphasis is placed on tangible and movable item, and there must be an agreed price of the good. Again, condition, section 12 talks about condition is the stipulation that is essential to the contract's main purpose. Breach of condition allowed buyer to terminate the contract and claim the damages. The condition here is there is an the main condition of main purpose of this contract is it allows the buyer, when there is an termination of contract, so the party who is aggrieved have this condition, have this situation that they can claim damages in case they have suffered. So for example, good must be must match the description, be of the merchantable quality and fit for a specific purpose. So reason being, if any product is not up to the mark or up to the guarantee or up to the promise which is made by the seller, then in that situation the condition can be raised and buyer can terminate that particular contract and claim the damages if the quality of product is not up to the mark. Then we have the warranty. It is covered under section 13. A warranty is a secondary stipulation. Breach of a warranty doesn't terminate the contract but allow buyer to claim the damages. So here the situation arises where the condition of good is there is a breach of warranty, so it doesn't terminate, like the contract is not terminated. Yes, the liberty is given to the seller that they can claim the damages from the buyer. Again, good must conform to the sample or the model provided. The reason being, if any good or services or product is been sold, a sample is being shown to the customer and they are promised that yes, the original product quality would be similar to this, but in case that product or thing which is delivered is not up to the mark, then in that situation buyer have this liberty to question that quality of that product and ask the seller for the damages for. So here are the key distinction. Condition, breach can be resigned by the contract. Warranty, breach allows the compensation but does not end the contract. Coming further, type of the condition, the very first condition is condition as to the title, section 14, the seller must have the right to sell the good. Again, here this situation is really important. The person who have the title ownership, original ownership, only have this liberty to transfer the property, right? If the owner itself don't have this particular authority, don't have this ownership title, how he would be able to transfer the title? Again, we have condition as to the description. Goods sold by the description must be correspond to that description. Reason being, whatever description is been mentioned in the good, the initial product must also have those, must fulfill those condition. It should not be like that the product quality is undermined, the quality of product is undermined. In that situation, it can be questioned. Again, condition of as quality or fitness, section 16 talks about good must be satisfactory quality and fit for the purpose. And the fourth condition as to sale by sample. Goods sold by sample must correspond with the sample. The reason being, we have already discussed that if any seller is giving a sample of the product and promising the buyer that yes, the original product which would be delivered with the similar condition which they are showing as a sample, that must comply with that sample, otherwise the whole condition would be vitiated. Again, transfer of property, transfer of ownership versus transfer of possession. The transfer of ownership may occur at a different time, but transfer of possession, again, these two are the different concept. When does a ownership pass? The first thing which comes, the sale of a specific good, that is section 20. Ownership passes when the good are identified and agreed upon. Then the second condition is sale of uncertain good. Ownership passes when goods are made as specified and ascertained. Again, third condition is the sale to agreement to sell. Ownership passes when the contract is completed but not before. Again, the moment that ownership is being transferred, then it is only considered that contract is completed. Risk and property. Ownership generally transferred with the good unless otherwise agreed. So here the condition is risk passes with ownership, meaning the buyer bear the risk once ownership is transferred. Reason being, once any electronic product has been transferred to you, is been delivered to you, the moment you have received your product, then all the risk which arises after the delivery of that product will lies upon you. Then the buyer would not take any accountability or the responsibility of the harm which has happened. Again, there are certain conditions where the warranty lies upon the seller only, but when it happens with the negligence of the buyer only, then seller would not bear any risk or accountability on the product. Then we have performance of sales of contract. Again, delivery of good. The first condition, delivery can be made through the physical transfer or constructive delivery, transferring the document of title. Then we have payment of price, which is discussed under section 32. The buyer is obligated to pay the agreed price, and if no time is specified, the payment is due at the time and place of delivery. Then we have the section 35, which categorically talks about the time of delivery. If it is not specified, the delivery should be made with a reasonable time. Reason being, we have also the failure to perform, which is discussed in section 36. If either party fails to fulfill their obligation, the party may seek the remedies of breach. Again, we have the rights of unpaid seller. It is really important concept, keeping the current market situation into consideration. The definition is given under section 45. An unpaid seller is one who has not received the payment for the goods sold, whose payment has been dishonored. There have been situations where a service or product has been delivered without any prior payments. In such situation, the seller is left with no choice, and he have to seek the payment yet to receive the payment from the purchaser. So rights of an unpaid seller, first when they right to lien, that is section 47, the unpaid seller has right to retain the possession of the until payment is paid. The reason being, if payment is not being made in the stipulated time, then the seller have to regain the possession of that particular product which he have delivered, until unless the full or partial payment as agreed upon is been made. Then we have right of stoppage in transit. The reason here in this particular situation, if the product is not yet been delivered, it is under the transit only. In that situation, if seller finds that, if seller feels that yes, the product cannot be product is under the transit, then only he have this liberty to stop the delivery of that particular product within the transit only. Again, right to resale, yes, if payment is not made, then the product which is to be delivered to the initial seller can be taken away from him, and it can be resell to another buyer on the default in the payment. For a specific period. Again, right to sue for the price. The seller can and the buyer sue the buyer for the price of the buyer refused to pay. Again, there are certain situations where a pre-order has been placed for a product. Okay, in that situation, if buyer denied to take that particular product, and initially a seller have already take all the initiative to finalize that product, he have already used his man and his resources to finalize the product, and now seller is refusing to take that particular product, then the buyer left with the seller left with no option to sue that particular buyer for the condition that yes, this particular product has been finalized upon your request, and you have to compensate for the labor charges and the product charges which he have already spent to finalize that particular product. Again, we have additional right to claim damages for non-acceptance and breach of contract. There may be situation where unlike seller will breach the condition, there may be any situations where there is a prior contract between the buyer and seller for a specific product, and there is an it may be from both the end basically, but here seller can claim the damages if there is a breach of contract. Then we have remedies for the sale of goods. The first, suit for the price. The seller can claim the agreed price if buyer refuses to accept the good. Again, suit for the damages. The injured party can claim the damages for the loss incurred due to the breach. Then there would be the specific performance. In certain cases, the seller can seek order for the buyers to complete the transaction, and rescissions that is discussed under the section 39, which says that contract can be rescinded for the breach with the party returning to their original position. Again, we have certain case laws which discuss about the seller's right. Court ruling on K.K. Verma versus Union of India 1954 case. Court rule on the seller's right to sue for the price in an event of buyer refusal to accept the good. The reason we were discussing that there are certain situations where the seller is making any particular product on the pre-order of the buyer, and he have finalized the product, but eventually the buyer is not ready to accept that particular product, as seller have already taken all the initiative. He has already used his manpower, he have already used his resources to finalize that product, and at this stage of time, if buyer refuses to take that product, then this liability would be on the buyers only to pay the cost for the product, and he can be sued in the court of law. Then we have the second example, that is S.K. Gupta versus G.N. Sood 1974 case. Court interpretation of unpaid seller and right to retain good. In this particular situation, court have already made a clear stipulation upon the unpaid seller's rights. Then we have conclusion. The Sales of Goods Act 1930 provides a clear legal framework governing the sales and transfer of the good, protecting the both buyers and seller. Here is sale is not just restricted to the rights of buyer or seller. It talks about the rights of both the parties. If any of the parties agree, they can approach the court of law under this set particular procedure, and all the definition have already been made clear. The parties can undergo while interpreting those condition according to their cases. Understanding the right duties and remedies in the contract of sale helps in navigating the commercial transaction smoothly. When there is no specific legal framework, if there is a legal vacuum, then there will be a situation where buyer and seller both will suffer and the commercial transaction would be affected, because in case there are breach, the buyers or seller will left with no remedy. So in this to mitigate such situation, this particular act was enacted. Thank you. That's all from my side.